Lecretia, actually.
You can't see it. She's there.
Well, Bill Dunn for Lecretia Myers.
Ms. Rayler?
May it please the court, the state of Kansas appears by Assistant District Attorney Kayla Rayler.
All right. Bill, you can't see your client?
No.
Everybody else is on here. I can see her. It's under the name C. Gilbert.
It may be the view that it's set up on. There should be 6 boxes on the screen.
I've got 5.
I got 5.
Strange. All right, but can you, Miss Leekmeyer, say something so we can see if Mr. Dunn can hear you?
I have 5 boxes.
Oh, I see her now. Oh, there you are. Okay. You popped up just there. I see. What do you say? I see you now, Lecretia. Okay. Anyway, so if the court please, the Lecretia Myers appears on this video.
She can't get a bunch of this.
Now she's gone again. Bill Dunn, counsel.
All right, we are here set down for defense motion for a reduction in bond. I'll just give a little background of the case. The charges are murder in the first degree during the commission of a felony and attempted aggravated robbery. First appearance was held back on February 13th, and bond was set at that time at $250,000 cash or surety. Mr. Gorman was appointed, but shortly thereafter, defendant retained Mr. Dunn's services, and he set it for a preliminary hearing. We held that preliminary hearing back on July 28th. At that time, I found there was probable cause to believe these crimes were committed and that the defendant had committed them. I kept the bond the same, and we set it for a motion hearing today. The only motion I see filed is that of Mr. Dunn for a bond reduction. So, Mr. Dunn, your motion.
Well, thank you, Judge. You know, it's not my habit to file successive motions. I hope I don't have that reputation. But the reason that I filed this was that at the time of the preliminary hearing, in my view at least, the evidence was thin. If you took the, you know, the view which the court must at a preliminary hearing, that you're going to resolve, you know, conflicts in the evidence generally in favor of the state, then I can see where Ms. Myers would have been bound over on kind of an accessory theory that she was, you know, driving the getaway car, so to speak. But there's no evidence at all that she did anything like pull a trigger, threaten anyone, or hurt anybody herself. So at the end of the preliminary hearing, I asked you to consider reducing the bond for this mother of 2 who has plenty of places to satisfy any house arrest requirements or tracking requirements. I also tried to convince you, Judge, that she has every reason to appear and defend the case. And also, I think we talked a little bit about the idea, is she a threat to the community, you know, a danger to the community? You heard my arguments on that. But the reason for this motion, the reason that I filed it, is that I felt that possibly you were influenced in your bond decision by some comments that were made surrounding that preliminary hearing having to do with robberies in Missouri. And, you know, there was some talk about, you know, other crimes that might be prosecuted in Missouri. And also, I think maybe you were influenced by the fact that one of the alleged participants is still at large. Well, I looked at what I thought was the evidence that my client might be involved in some other activity over in Missouri. And I was guided by the prosecutor in looking at that. And it's, again, my view, it doesn't matter, I guess, what my view is, but it's very thin. It has to do with cell phone towers and cell phone locations. Whatever the strength of that evidence, there has been no further prosecution filed that I know of regarding my client. So, the proof is kind of in the taste of the pudding there. They apparently don't think they have enough to file anything, at least at this point. So if you were influenced, or if you were thinking about other prosecutions while you're making your bond decision, I think you can discount that, at least, today. $250,000. Certainly I realize first-degree murders is about as serious a charge as you can have. This is a felony murder theory, though, and it's an accessory, and the accessory is really, I think, based maybe on one statement that was unrecorded, reported by Detective Gunzenhauser, where he says, my client said, I thought they were going to rob a house or something like that. I was going to rob a home, something other than the Pizza Hut. You certainly are a very experienced legal person. You've been in trials. I don't know how you think that's going to play in front of a jury, but I suggest to you that there are certainly going to be arguments that we can make with regard to that statement. And even if the jury were to absolutely believe it were made, it still doesn't show my client's willing joining in this Pizza Hut robbery, as though she wanted it to succeed, which, as you know, is the requirement for conviction as an aider and abettor. So because there have been no further actions taken against my client, because, we don't know what's going on with this third guy, if he's ever going to be apprehended or if he's going to remain at large, because my client really didn't hurt anybody, and as far as I can tell, there's no evidence that she ever intended to hurt anybody. Because of her personal situation, that is, of being a young mother with two children who need her, because she isn't a threat to the community, and because she can fulfill, whatever tracking requirements are placed on her as a condition of bond, I'm asking you at this time to consider reducing her bond to something that's going to allow her to care for her children and assist in her defense. I guess an additional factor is we got no idea when we're going to actually get a trial in this case. I haven't had a trial, a realistic trial setting yet. And I don't know when those are going to start. So we'd ask you to reduce the bond. Thank you for listening.
Miss Rayla.
Judge, before I make any argument, I believe the defendant was trying to get somebody's attention to make a couple of statements. I don't know if she needs to talk to her attorney or wants to direct something at the court. She was holding up one finger, trying to get somebody's attention.
Well, my guess would be that Mr. Dunn would not counsel his client to make any statements to the court right now. Certainly, if they wanted a moment alone, either one of them could tell me that, and I would do that. So, Miss Leekmeyers, look, I don't give legal advice, and I suppose if you want to tell me something and won't be deterred, so be it. But my guess is Mr. Dunn, having been in his position before, would counsel you that there's not a lot to be gained and everything to be risked by making statements to the court at this time. So with that, do you need a moment with him? Mr.
No,
Dunn, do you need a moment with your client?
he had already answered it, so it went away.
Okay, all right, sounds good. You okay, Mr. Dunn? You don't need a moment alone?
I guess not.
Okay, all right, Ms. Rayler.
Judge, the state would object to a bond reduction. The state's not required to present all the evidence at a preliminary hearing, just enough for the court to bind over in a particular case. I did provide defense counsel with some of the evidence that I have received regarding the Missouri case. I have been in contact with Missouri. It is their intention to file a case. When, I don't know. As for the third individual in this case, he was booked into the jail last night. So he's not on the run anymore. But I don't think that is a factor the court should consider. This is an individual who, based on the evidence the state and the defense reviewed, has been implicated in robberies that happened prior to this homicide. The court's heard a little bit of the evidence that was presented at the preliminary hearing to bind the defendant over. The state believes that $250,000 is sufficient. The defendant does have prior failures to appear out of municipal court that I reviewed this morning. Other jurisdictions, I don't know. But I did see that she does have prior failures to appear. She has a criminal history but she's looking at a life sentence right now.
Yeah, all right. Well, look, I mean, there are competing considerations here in all of these, and I'm not sure exactly. Look, part of me is always concerned if I look at something and go, heck, I'll reduce her bond by, $10,000. That doesn't do her any good. And for some people, a bond of 250,000 might as well be a bond of 250 million. So that is a consideration, as is the fact that we are sitting here without speedy trial clock running in any cases, at least statutorily. And that is something that weighs heavily on this court's mind. I have to tell you that I recall this preliminary hearing, and I recall some vague mention of other cases in Missouri in which they're looking at cell phone tower pings on people's phones and things like that. I can't even recall as I sit here whether that was during the prelim itself or whether it was during the request for a bond reduction at that time. But in either manner, I don't particularly find that specter persuasive one way or another. Much like I don't find the facts of whether or not it was a close call in binding over, or whether I think a jury will convict or acquit or anything like that. It's kind of really stepping out of my purview. There are two things that I'm supposed to consider in setting bonds. One is public safety, and one is assurance of appearance in court. And really, I don't think that there's anything else that I shouldn't be here weighing the evidence, deciding whether the evidence of charges in other jurisdictions are going to be charged or whether there'll be convictions and all that, except to the point that it weighs on whether or not she's a danger to society, whether or not she's a risk of flight. And frankly, I don't feel like I need to get to those, because given the charges in this case, and the fact that the defendant is facing a life sentence, I do find, particularly from the evidence that I heard, that Ms. Leekmeyers does present a danger to society in getting involved with things like this. And with that, I recognize her lack of criminal history. I also understand that these are charges at this time and certainly not convictions. But given the nature of the charges and the evidence heard at prelim, I do feel that she's a danger to society. But more than that, and weighing much more than that, is my belief that she's a flight risk. While it may be true that she's had some failures to appear in municipal court, you know, those are a whole different matter, different kinds of, I guess, considerations by defendants, whether or not to appear in court. I don't know that something that might lead somebody to miss a traffic ticket would really be the same kind of considerations that might cause them not to come for their murder case. But I do think, facing the life sentence that she is, that there is a substantial risk that Ms. Leekmeyers won't appear. So look, I do have this concern in those matters, but I also, as I mentioned, and I'm not discounting the fact that we're not going to see trials anytime soon. Frankly, we have a month and a half that have gone by that would have been ticking towards the defendant's speedy trial rights that are just simply not doing. So look, this is what I'm going to do. I don't know if it means anything to the defendant. It might not. I think, look, when setting terms of bond, I think there are terms of bond that can support public safety, and they are not monetary in nature. Look, putting a $1 million bond or a $5 bond on a person has no effect on their likelihood to be a danger to society. So I think it has to be other things. So any bond that Ms. Lecretia Leekmeyers would make would also require a house arrest component, whether that's through pretrial services or if Ms. Leekmeyers wants to seek her own resource for that. So I'm going to reduce the bond to $100,000, but I'm going to add the component that if she makes that bond, she also must, at her expense, obtain house arrest monitoring. So look, I don't know that whether 250,000 or 100,000 makes any difference to the defendant, but I do feel that a number that would cause her to put up substantial assets to make would be sufficient justification or sufficient motivation, I should say, to appear in court. I don't know that 25,000, if she were to make a surety bond, is much different than 10,000. So I am going to, that's what I'm going to do. But new bond will be $100,000 plus house arrest. And that's where we're at. So beyond that, I know that my assistant has this on a case that is set for, will be set for status conference and jury trial as soon as we get the go-ahead to start setting those. I really do hope that that is forthcoming in the next short period of time, but I have no reason to guarantee you that.
You know what they do?
Other things that we need to set this for, Ms. Rayler.
Judge, I have us set for a motions hearing on September the 22nd at 1 that we sat from the preliminary hearing.
That's right. That was the motion to admit defendant's statement, correct?
Yes, I believe
Okay.
so.
All right. So yeah, we set this one short of that. We have September 22nd at 1 p.m. for that motion. Are there any other motions that anybody's intending to be heard on that day?
The state may be filing a 6455 motion.
All right, do it quick, please, so that it can be done and Mr. Dunn would have a chance to respond if need be.
Yes, sir.
Mr. Dunn, are you aware of any motions that you're intending on filing anytime soon?
I'm not aware of any. I got to say that it doesn't mean there aren't any. I mean, maybe I haven't given enough thought to the case to.
They don't freeball with the questions. The new kind of stuff, and they probably cheating.
All right, where's that
Sorry.
coming from? Anywhere?
It's coming from the witness.
All right. All right, I'm just gonna mute her because I can't, that's interrupting our hearing.
I'm not aware of any right now.
All right, so anyway, that's my ruling on the motion for bond reduction today. And then we will see you all on the 22nd at 1 p.m. Anything else for our record today?
I don't believe so, Your Honor.
Not for me.
All right, we are adjourned. Everybody have a good weekend.
Thank you.
Thank you.